Today's seminar is called Life to Legacy. I've invited David Taylor, a financial planner, Rebecca Parry, a family lawyer, and Danielle Little, who is an estate planning and litigation lawyer, to help me work through a hypothetical scenario of Ben and Jane, so we can understand how those three professions work together to ensure that Ben and Jane's assets are protected and their risks are mitigated. Now, Ben and Jane are married. They've got one child together called Grace, and Grace is 10 years old. Ben also has twin girls to a previous relationship. His twin girls are called Chloe and Zoe, and they're both 18. In relation to personal assets in this scenario, Ben and Jane both jointly own their principal place of residence. They own that one as joint tenants. They also have $300,000 in cash and a share portfolio worth approximately $200,000. Now, Ben and Jane also own an investment property, but they own that one differently. They own that as tenants in common, for which they each have a 50% share of that investment property. Jane has a physiotherapy business, and she operates that through a company, and she has one share in that company. There's also a self-managed superannuation fund in play. Ben and Jane are both members of that, and the self-managed super fund currently has a balance of $550,000 in cash. When we look at the liabilities of Ben and Jane, the primary one is just a mortgage over the investment property. It's still got $500,000 owing on that investment property. And in terms of business expenses, Jane's main business expense is just the rent for the premises that she operates her physiotherapy business out of. So in today's seminar, I'll ask David, Rebecca, and Danielle to take you through each of their individual elements so we can understand how the professions work together to ensure that Ben and Jane's scenario is appropriately managed. Now, it's important to note that today's seminar is educational and instructional only and should not be construed as financial or legal advice. As with all key life decisions, it's absolutely imperative that you go and see the right professional to get advice that is tailored to your unique and individual circumstances, and you should engage the appropriate legal and financial planning professionals to provide you with that advice. I'd like to introduce David Taylor, a private client advisor at Morgans in Edward Street. David provides tailored and customised financial advice and solutions for his clients. Some of David's services include wealth management, superannuation advice, self-managed super funds, portfolio management, and retirement planning. Welcome, David. Thank you for joining me on the couch today.
Thank you.
Now, I've given an outline of Ben and Jane's situation. Can you talk me through why asset protection is particularly important for them?
Look, I think there's a few things that in Ben and Jane's situation that we need to consider. Primarily, Jane's business structure is going to be something that we would want to review with an accountant to make sure that there's a limited liability to the business and that doesn't creep over into their personal asset and wealth journey and the assets that they've accumulated on a personal level. That would be the imperative thing. The other factor that I think is important to consider is the fact that they have a blended family. So they both have children from other partners and the distribution of wealth and assets through the estate would be an important one to consider as well.
And there's a bit to work through there for Ben and Jane. So can you talk me through how you would help them kind of clarify and prioritise their financial goals?
Yeah, certainly. It's a matter of having some in-depth conversations around their goals and priorities, understanding who they are as people and there's a lot of experience that comes with and different experiences that come with a blended family. And as a result of that, you want to understand each of their individual motivations, each of their individual desires to build wealth as a couple, as a coming together. To build that over time is going to be important, but it's going to take some time and some in-depth discussions to find out what their priorities are and what they actually want to achieve together. They've done well to build the asset base that they have accumulated, but we want to make sure that that's A, protected, and B, continues along the desired path. We need to go really in depth with their objectives and not just from a short-term perspective, but also a medium-term and a longer-term perspective to make sure that they're on track and monitor that and help them get there.
Okay. And given Ben and Jane's life stage, I guess, for want of a better word, do you sometimes find that there is a bit of a conflict between trying to provide for like the short-term goals of education of the children and so forth, which can be a bit diametrically opposed sometimes to what you want to do for your long-term goal for retirement planning and accumulating that long-term wealth?
Yeah, absolutely. It's always a trade-off. There is the education component and funding kids through whether they want to fund those kids through private schools and high school, through to whether they want to fund them for university, postgraduate studies. Maybe they want to fund them through medical school if that was their chosen path. And that always comes at a cost to the accumulation of assets towards retirement. So it's talking through those trade-offs is going to be the biggest challenge, and prioritising them. And it's neither one nor the other. It's not black or white, but finding the happy medium somewhere in the middle there where you can cover off on achieving both of those goals, at least partially, and working towards those goals in a balanced manner.
So in terms of self-managed super funds, we've spoken a bit about the possibility of setting up a self-managed super fund and purchasing commercial property through that fund. What are the benefits seem obvious, but what are the risks of this strategy as well?
Self-managed super funds are a great vehicle, and there's going to need to be an in-depth discussion around the pros and cons of those with Ben and Jane to make sure that they suit. Jane would have the ability to set up a self-managed super fund and buy a commercial premises to run her business out of through a self-managed super fund if she so desired, and if it was appropriate, if she was, let's just say, had an understanding of the risks and trade-offs. So those risks are substantial in that you are the trustee of the super fund or the director of the trustee company. Thus, you fall outside the usual APRA protections when it comes to these sorts of things. You'd be protected by, if you're in an industry super fund or a retail super fund, you'd be protected by the usual fallbacks and industry regulators, which you take on that responsibility yourself as the director of a corporate trustee of a self-managed super fund, or indeed a trustee of a self-managed superannuation fund. That's probably the biggest risk. You want to make sure that if you're setting up a self-managed super fund, and particularly buying property in it, that you balance the asset allocation in that self-managed super fund. You also want to make sure that it matches your investment strategy. That's a big one, because investment strategies can be neglected and put to the side. And if they're not updated on a regular basis and the assets within that match that investment strategy, it will be picked up by an auditor and possibly found non-compliant, which that then causes a few issues around, non-compliant is not a good thing.
No, never is. No. All right. So it sounds like there's a few extra layers of complexity and things to consider if you're going down that self-managed super fund path. So the trade-offs there, obviously the upside seems to be a significant attraction, but how do you work through with clients to decide whether or not they should consolidate all their super into a self-managed super fund, or whether perhaps they should just leave it in a traditional industry situation?
I think we need to consider the costs and the responsibilities. With a traditional industry or retail superannuation fund or master trust, you don't have the costs of accounting, you don't have the costs of audit, you don't have the costs of administration. Although an industry super fund will have an administration fee, these other funds, the self-managed super fund, you pay these sorts of things far more directly. It's a combination of a process of individual understanding of the risks, and we would want to make sure that you're very aware of the risks and the process and how a self-managed super fund works. They are trusts, so they work in a similar way to a trust, but they have the responsibilities of a superannuation trustee, which is again an extra level of responsibility. So you're taking on that responsibility yourself, or Jane would be, and Ben. We would be making sure that they understood the responsibilities of being a director of the corporate trustee of a self-managed super fund, because that would make things a lot easier from a estate planning perspective. More on that from Danielle later. And we would just make sure that they had access to a lot of educational resources around self-managed super funds so that they understood, and we would help them to work through those and make sure that they really, really understand the responsibilities that it entails. Because it's not a decision to be taken lightly, and it is a decision that should be given a lot of consideration. Self-managed super funds give you the ultimate level of control in what you can invest in, how you choose to invest within the superannuation legislation, but they also have that ultimate level of responsibility too.
Okay. Shifting on from self-managed super specifically to a little bit about personal risk. So what are the key personal risks that people often overlook when they're thinking about just asset protection more broadly?
Yeah, it's really important. Everyone seems to have a superannuation fund, and they tend to go, well, I've got insurance through my super fund. So you most often, what I see is clients with a superannuation fund that might have some life insurance and some total and permanent disability insurance. Sometimes you'll see some income protection insurance in that, covering a lot of 75% of your income for a period of time should you get ill or injured. Life insurance is pretty straightforward. If you pass away, that is going to your estate and whom you nominate as your beneficiary. And total and permanent disability is one of those insurances where you're basically not meeting, typically three of five activities of daily living. The one thing I see that is most often missed is trauma insurance. And that's one you can't have through your superannuation fund, simply because if you were to have a successful claim, it wouldn't be able to meet a condition of release, and you wouldn't be able to get the benefit out of the super fund, the financial benefit. So most people that haven't proactively looked at their personal risk insurance need to consider trauma insurance, most definitely. On a periodic basis, you want to make sure that you review your cover. So make sure that if you're taking on new debt, i.e. buying commercial property in Jane's circumstances, is your existing insurances adequate to cover that debt? Or would you want to increase your insurances to make sure that you were covered and your surviving spouse or surviving children aren't left with the debt in that case?
Can you give me an example of what sorts of things trauma cover you for that you're not getting coverage for with the other policy types?
Yeah, trauma is a defined event. It's about 50 different events, depending on the policy. So it can cover you for the big four is cancer, heart attack, stroke, and bypass, heart bypass. But there are, as I said, up to 50 different events, including blindness, deafness, multiple sclerosis. It's all dependent on the policy, but it's one of the most important insurances because, in all honesty, everyone knows someone that's gone through the cancer experience, and it's one of the most claimed upon insurances as well. So really important that's reviewed, and periodically reviewing the entire portfolio and the entirety of the covers to make sure that it maintains relevance to the client's circumstances and objectives.
Okay. And just on the income protection insurance, I've always been curious why 75% is the number that gets covered and not the whole amount. So is there an underlying logic behind that?
There is. What incentive would there be to go back to work if 100% of your income was funded?
Yeah. Okay. Yeah. So it's just creating a comfortable bit of friction, so there's incentive for you to go back to your usual occupation.
That's right. And look, a lot of policies used to cover you up to age 65. There's been a lot of reform in life insurance and personal risk insurance in recent years, and a lot of policies don't offer that anymore. And they've cut back to a benefit period of about 5 years, generally speaking, again, dependent on the policy.
Okay. And is that something someone gets to choose, or is this just a greater policy shift?
Greater policy shift, but you most certainly can choose a benefit level of 2 years, 5 years. You can choose your waiting period to be flexible on your premiums, 30 days, 2 weeks, 30 days, 90 days, a year. You can have waiting periods of 2 years. So it is relatively flexible, but it's changed a lot in recent years.
And I guess that just allows you to kind of customise the premium level to suit your circumstances.
Indeed, and that's the other side of this. You can insure yourself up to the wazoo. However, it's about a premium affordability as well. You can cover yourself, but at what cost?
Now, let's talk a little bit about business structure and asset protection. I noticed Jane's structure seems to expose assets to risk. What are some of the protective strategies you could recommend that you might want to consider or implement in that situation?
Look, we would work with the accountant pretty closely on this one because we're not, as financial advisors, we're not business structurers or anything like that. But we want to understand, is she running her business through a company? Is she running it through a trust? Is she running it as a sole trader and just through herself personally? Generally speaking, that would probably be not necessarily a good thing, simply because it would expose her to, and her personal assets, her investment properties and cash, etc., to potential liability claims if she was sued for any particular reason. So we would work with the accountant very closely on that one and get their suggestions on how she could be a little bit more protected. A really important thing to include in that would be that self-managed super funds or super funds in general, if there's a history of contributions over time, can be protected from creditors. So if something bad were to happen and Jane was sued and the business had to fold, if she's continually and there's a history of contributions to superannuation over time in the general course of business, that would be a large level of protection against that particular entity, her superannuation, from being accessed by creditors.
Okay. So is this a case in business where sometimes just having professional indemnity insurance is not sufficient? Can people kind of find that falls short sometimes?
That's a good question. I'd refer that one on to the general insurance broker, because professional indemnity can only go so far. Workers' comp, I mean, again, you can insure yourself right up to the eyeballs. Cyber insurance, direct management liability insurance, directors insurance, professional indemnity, professional liability, all of these can really add up. So it's about finding a balance. And look, we just stick to the personal risk insurance side of things because it's such a vast area and such a vast thing to cover that I'd probably say general insurance there, structuring with the accountant, and we'd look after the personal risk and superannuation side of things.
Okay. Let's talk a little bit about diversification. So I noticed Ben and Jane have a heavy tendency towards property. Are there guidelines, or is it simply just a case of prudent investment that you would start the conversation around perhaps expanding asset classes, investment classes?
Yeah, look, if it's the person's objective, we can't really, we don't want to really get in the way, but we also don't want to encourage concentration risk. It would be the same if someone came to me with, a $500,000 portfolio and half of that was in BHP or CBA. I'd start by going, well, that is a risk because half of your portfolio is concentrated in one asset class and in one particular stock. Property is great, and you can certainly diversify property in the same way that you can diversify stocks. You can have commercial property, you can have industrial property, retail property, etc. But it is one asset class of multiple different asset classes. So I think it's the first rule of Warren Buffett's famous rules. The first one being that is diversification. The second one being don't lose money.
Yeah, don't lose money. That's good advice. Yes, a good rule.
Yeah. So absolutely just start talking about it, introduce the benefits of other asset classes, understand what they know and understand and what they have their considerations and thoughts and feelings around other asset classes, and start to build, again, another education piece around that and see where they feel and hopefully over time guide them towards a more diversified asset base.
Okay, so it kind of pays to spread the eggs around to multiple baskets, not have them all in one spot. David, let's talk a little bit about assessing someone's capacity or appetite for risk and the role that plays in their investment strategy.
Yeah, so as financial advisors, we typically use a tool called the Risk Profile Questionnaire. That comes out with an overarching asset allocation guidelines depending on what sort of investor you're determined to be it a conservative investor, moderate, balanced growth, or aggressive investor. That's all well and good. That gives us, a growth investor might be 80% towards shares and property and 20% towards cash and fixed interest investments. It's fine as a guideline, but what does the client really understand in each of those asset classes? I say property, as I said earlier, it's got a lot of definitions: commercial, industrial, residential, business. Lots of definitions of property. Similarly, there's a lot of definition of shares, international shares, domestic shares. Fixed interest can mean credit or bonds or a whole bunch of other things. So what does the client understand about each of those different asset classes? How do they feel about each of those different asset classes, if anything at all? And how can we blend what their comfort and level of risk with what their objectives are?
Yeah, and I guess time to retirement, like those sorts of chronological questions would come into it as well.
And that's the real biggest diversifier is time. The closer you get to retirement, the more conservative people tend to be. And, that's not necessarily a bad thing.
Yeah, okay. So estate planning in blended families can be pretty complex. What are some of the strategies that we can chat about to ensure that assets are distributed in a fair and tax-effective kind of way?
From our perspective, it would be, and Danielle will touch on this in a lot more detail than I will, but from my perspective, it would be about managing the super fund in one or the super funds, depending on whether they chose a self-managed super fund or not, or were sophisticated enough to recommend a self-managed super fund and go down that path. We would look at making sure that those super funds had binding death nominations in place, because it's a very clear definition of where they want those funds to go to. Only certain people and there's only certain eligible beneficiaries to be named as a binding death nomination, but it provides a level of certainty and clarity. And making sure those binding death nominations are valid is key. Sure. They need to be signed by 2 independent witnesses on the same date as the benefit or the member is signing those binding death nominations. It's really imperative that it's valid and clear, and it splits up those the benefits of the super fund in a percentage basis. So Ben may want his benefits to go to his kids, and similarly Jane to her kids, or they may have a combination of the 2.
And these nominations, can they expire, or you just do it once and it's like that forever?
It depends on the super fund is the short answer of that. The long answer is some are don't lapse. They're non-lapsing. Others, and the earlier ones that I've seen, tend to lapse every 3 years. So, I've come across a few times in my career where they have lapsed. Yeah, many a time actually.
Okay. So it seems like this whole planning process involves more than just speaking to a financial planner. How do you work through the process with clients to understand what types of professionals they might need to make sure they're ticking all those boxes?
It's through those in-depth discussions. So making sure that, look, we see this risk here. Have you talked to your accountant about that? We see this risk here. Have you talked to your estate planning lawyer about that? Do you have a will? Do you have an enduring power of attorney in place? We recommend you get that checked out for sure. But it's all through just understanding the client's situation and seeking to understand. Seek to understand is the first tenet of any meeting that I have, and trying to understand their circumstances and their goals and help them to facilitate anything where we see the gaps.
Okay. So if our listeners today are thinking about restructuring their business, asset protection, self-managed super funds, what are some of the first steps they should be thinking about?
The first things you should be thinking about is getting a handle on where everything is, what you want to achieve, goals and objectives. It can be as easy, I'm looking to ways to save tax. Well, it's not particularly specific.
Yeah. But I think we all are.
Yeah, indeed. But how do we do that? So that how much tax are you paying now? What's your circumstances? How can we go about that? What's your asset base? And we know that with Ben and Jane, but anyone else what are the ways, what's your situation, and how can we do that for you? Let's talk about the strategies that we can implement for that. Are you salary sacrificing? That might be one. Do you want a salary sacrifice, or do you prioritise paying off debt? Yeah, that would be the things I would, you just got to have those in-depth discussions.
Very good. Well, thank you, David, for joining us on the couch today. Really appreciate you sharing your wisdom and insights.
My pleasure.
Our next guest is Rebecca Parry, founder and principal of Parry Coates Family Law. Now, a lot of people think you only need a family lawyer if you're going through a relationship breakdown or have a dispute over the custody of your children. But as we'll learn today, there are things that you can do while your relationship is happy and healthy to ensure that actually doesn't happen. We'll talk today about financial agreements and how they can remove all of the friction from that planning process. Rebecca, thank you for joining us on the couch. I'm really curious to understand more about financial agreements.
Well, it's a good question, and I think it's becoming more commonly asked these days. But financial agreements are essentially a contract between 2 people who are either in a relationship or who are contemplating entering into a relationship, living together, or they can be used after people separate, and we know them as prenups if it's before a relationship or during a relationship.
Okay, so a financial agreement you can use when you separate, but if you're not separated and you're not thinking of separating, it just kind of gives you a way to work through that while things are going well. Is that kind of the underlying logic?
Correct. So if we were to use the financial agreement after separation, so either a de facto relationship or a marriage breakdown, and we were to use a financial agreement after that breakdown has occurred, then that's a way to divide the parties' assets, superannuation and liabilities. But parties can also enter into a financial agreement when they're happy. or they're contemplating moving in together, or they're contemplating marriage, or they can even be used during your marriage, or you could be living together for a few years and you decide we need some form of asset protection.
Okay. Is it reasonable to say that that's actually probably a better time to work through that type of scenario when, you don't, I guess, have the stress or pressure of relationship breakdown? Like, do you find that that's actually a good way to be objective about what that might look like?
It can be sometimes. It's not a very romantic conversation to have.
It's not for date night.
No, it's certainly not for date night, not if you want the date to go well, but it is a common sense approach. It's a good conversation to have if you are wanting to protect your assets that you've worked hard to build up.
Yeah. Is there a delicate way to approach this as a subject in your household? Like, do you find that sometimes it's one of those awkward things to kind of put on the table and understand what the other person might be thinking?
I think it probably could be, but I'm seeing in my practice that it's more common now for the younger generation to actually be entering into these types of agreements. And I think whether it's because of that generation and they're able to have those types of conversations more easily, I think it's easier for them. If somebody is in their 50s or 60s and they're coming into a second relationship, they've generally been through a separation, so they want to avoid that. And I think what's happening is that they're having the conversation from the beginning.
Okay. Like, how expansive is a financial agreement? What types of things can it cover?
Well, if we're talking about asset protection, we're talking about the prenups, okay? So you haven't separated. So what we want to do is we want to protect what you've built up.
Yeah.
So we call that separate property. So let's take Ben and Jane, for example, and I act for Jane. Jane has a business. She's got some assets that she wants to protect, and so we call that separate property. So the idea behind the financial agreement is to quarantine that separate property in the event that they separate.
Sure.
Okay.
And is that a case of kind of establishing what each party had at the beginning, and then as they progress through their relationship, how is that kind of managed?
Yes, we need to outline what they brought into the relationship so that we can quarantine that separate property. And then if they decide to acquire property during the relationship together, then the financial agreement can outline how that property is owned. So, for example, if Ben and Jane wanted to buy a property, a home, then they might register the title of the property as tenants in common, or they might register it as joint tenants. And so the financial agreement can outline how that registration is to occur.
And does a financial agreement cover more than just assets? Like, obviously, if two people come together and they've both got a house, I imagine it covers those types of things. But in addition to assets and material goods, are there other things that it can cover as well?
Absolutely. It can cover what we call spouse maintenance. Mm-hmm. So spouse maintenance is paid where one person of the relationship has a need and the other person has a capacity to pay. So if somebody separated and they had a need, that is that they couldn't meet their weekly expenses, rent, petrol, food, from their income, and the other person had a capacity to pay and contribute, that's what we call spouse maintenance. But financial agreements can also contract out of somebody's liability or responsibility to pay spouse maintenance if you were to separate.
Okay. I imagine there's a process to working through a financial agreement. Can you talk a little bit about what that kind of looks like?
Well, before they see me, more often than not, they have to have that romantic conversation about whether they're going to have this financial agreement in place. And then once it's decided that that's what is needed, then my client, Jane, for example, would make an appointment to come and see me, and I would go through the process with her. Why are we doing a financial agreement? What do we want to include in the financial agreement? An area that people tend to forget about is if the relationship breaks down and we're living in a home, who owns the home at that point in time and who vacates the home? Because if you separate, clearly the relationship's uncomfortable and perhaps untenable, and so somebody has to vacate the home. So that's another area of paragraphs, if you like, that can be included in a financial agreement.
So it's not just like ruling a line down the middle and this is your side and this is my side.
No.
So you've advised Jane. I imagine Ben needs to go and get his own legal advice in this regard?
Correct. So there are certain requirements for financial agreements to be binding under our legislation, and that is that each of Ben and Jane must have independent legal advice. So I can't advise Ben as well as advising Jane. Okay, so Ben must have independent legal advice, and that legal advisor will go through what the financial agreement entails, the advantages of the agreement, the disadvantages of the agreement, and the effect of the agreement on their rights.
We've spoken a little bit about what that initial consultation looks like. I imagine disclosure is obviously pretty important in this, so I would imagine that each party needs to be pretty frank and open in that regard.
Absolutely. If financial disclosure does not occur, then how do we know what we're protecting? Okay, so for example, I act for Jane. I ask Jane about her financial circumstances, what her assets are, the value of the assets, her liabilities and superannuation benefits. That same question needs to be asked of Ben so that we're all on the same page in terms of what are we protecting with the financial agreement. So financial disclosure is the exchange of financial documents. So if I said to Ben's lawyer, could you please provide me with financial disclosure? That means I'm asking for tax returns, bank account statements, superannuation statements. If they've got real estate market appraisals for the value of a property, then I would ask for those particular documents. If somebody has a business, then the financial statements of that business would be important as well.
All right. And so if someone has not disclosed appropriately, what impact does that have on the validity of the agreement?
Well, if they separate and we have to implement the terms of the agreement, it could be a factor to have the agreement set aside.
I think one of the challenges people often wrestle with here is unequal contributions, maybe past or present. How do you kind of work through that process where one of the parties may have contributed more in the past, but potentially will contribute less in the future? Like, how do we work through that, I guess, equalisation scenario?
Well, a prenup or a financial agreement that we're entering into now will need to cover all of that. So, for example, Ben and Jane want to buy an investment property. Jane's contribution to the purchase price is 75% of the purchase price, but Ben's is only 25%. Then we need to either document that in the agreement if it's known at the time we're drafting the agreement, or what we do is we put in clauses in the agreement that outlines how unequal contributions are dealt with. So if they were to separate and they needed to sell that investment property as part of the division of assets, then the net proceeds of sale would be 75% to Jane and 25% to Ben.
Okay. Now, Ben and Jane, we've kind of discussed in their scenario, they've already got kids, they have a bit of a blended family, but I guess to look at it from a slightly different angle, if they were a younger couple just starting out, maybe they hadn't had kids yet, but they planned on it, maybe they were going to have one kid, maybe they might have 10 kids. How do we provide for that in the financial agreement?
I would be saying to Jane, we need to make sure that we have a review mechanism in the agreement. And that could be either on the birth of the first child, or it could be on the 5th anniversary of the date of the agreement. And it's important that we do that because, as we all know, children can change everything. They're expensive. If one of the parties is the stay-at-home parent, then they're not earning an income, which means that they're not contributing to their super, whilst the other person's super is increasing in value. Okay, so if they then separate, who's going to be that stay-at-home parent? Is there a stay-at-home parent, or do they both work? So there's lots of variables when children come into that relationship. So we would say for a young couple, you need to review it on the birth of the first child or on the 5th anniversary of the date of the agreement. And there are some solicitors that will refuse to act for clients in these types of agreements if they won't do a review clause.
Okay. Expanding on that, I guess, from moving from children to just future assets and acquisitions, like how how fixed is your financial agreement at the point of entry? And is there a way to construct that so if you buy extra properties, etc., you don't need to review it? Or every time something materially changes, should that be a trigger point to review whether it still fits your needs?
If that's what they want to do on material significant changes, they can review it. Or what we can do is we put at the back of our agreements what we call an acquisition schedule, so that on the purchase or acquisition of big assets, a schedule's kept, and that is the details of the purchase, the date of purchase, the purchase price, the contribution, financial contribution to that purchase, and that kind of gets around to some extent having to review or change. You can't change an agreement; it has to be terminated. It gets around that little hurdle.
Just gives a bit of extra flexibility.
Yes.
So if a couple decide to go through this process and actually can't agree at this point, like at the initial point of coming up with how to structure their financial agreement, how do you work through those types of situations?
It's difficult because you can't force somebody to enter into that agreement. There are cases that have been heard where the agreements have been set aside by the court, where there's been duress or unconscionable conduct and pressure being put onto one party to enter into an agreement. And that's generally where there's an imbalance of power or the financial circumstances. So if one person does not want to enter into that agreement, you can't force them to do that.
Okay. As Ben and Jane work through this process of constructing their financial agreement, are they able to talk to each other about it, or should all their correspondence be with their respective?
No, they can speak with each other, especially at the outset, to talk about what it is that they want to include in their financial agreement. I think when it comes to the pointy end where the agreement's in its final form and advice, independent legal advice is being given to your client, then you're not going to talk about that advice because that's confidential.
Sure.
Yeah.
So moving to the end point there, I guess, you've been through the initial consultation phase, we've been through drafting the agreement, both parties have kind of agreed. So what does that whole actually signing it and executing it, what does that situation or what does that process look like?
You can either just do, once the agreement can't be signed until your client has received the independent legal advice. And more often than not, it's in writing because your client is signing a contract. And so the advice is very important. So once the advice has been given to both clients by their respective lawyers, then the agreement can be signed. You can come together, the four of you, and sign the agreement. There's no problem with that. Or you just sign it with your client and the original goes over to the other side to sign. That's the easy part.
Okay. So a financial agreement is effectively allowing people to kind of pre-agree that if their relationship was to, disintegrate at some point, then when people are thinking about that more objectively and less caught up in the emotion of the situation, everyone's kind of just pre-agreeing how all of those assets and things should be divided up.
Yeah, they are.
Okay.
What you are doing is you are avoiding the lengthy and expensive costs associated with litigation after you separate. Yeah. And so if you're wanting to protect your wealth during your relationship or even an inheritance, then this is the best way that we have available to do that.
Okay. So you've obviously had a fair bit of experience working through these scenarios. Are there any pitfalls or things that people should be aware of before they go down this path?
Yes, don't hide your assets.
Okay, that's a good one.
Because it's the assets that we're trying to protect, so what's the point in hiding those? Don't place pressure on the other party to sign the agreement. Making comments like, this wedding will not proceed unless you sign this financial agreement. That's a big one. The minute a client says that is the minute that you give a lot of advice and perhaps...
Well, that's duress, really.
Correct.
Yeah.
Correct. I often say to clients, if I've dealt with them in their separation, if you are going to contemplate entering into a new relationship, you need to come back and see me.
Yes, good advice. Before we wrap up today, just what do you think is the most important takeaway for people to think about in relation to financial agreements?
Well, Brock, we work hard to build up our wealth.
Yes.
And so ideally, we want to protect that wealth as best as we possibly can. And I think one important factor in a financial agreement is that if I own a home now and I enter into a relationship and I want to protect that home. If I sell that home during the relationship, then I can protect that next asset that I buy that comes from those proceeds. So we call it an incremental increase in your asset base. Okay. So I might have the home that I live in, and then my partner might move into that home with me, and we decide that we are going to purchase a home together. So I sell my home that was called separate property. Yep. The proceeds of sale that I retain from that sale are mine. Okay. They don't form part of the joint asset pool. It's still my separate property.
Oh, so you always retain that. It doesn't
always retain that.
Get put in the bucket.
Correct. So if I received an inheritance, the funds that I get from the inheritance, if I use those funds to buy a beach house at the Gold Coast, then it's still my separate property because it's come from the inheritance, which has been defined in the financial agreement.
Yeah, and if you've come across an inheritance, I imagine the person bequeathing that to you is trying to look after your best interest anyway.
Correct.
Yeah. Okay, excellent. Thank you, Rebecca, for joining us today. We've really appreciated your wisdom and insight.
Thank you.
I'd like to introduce Danielle Little, founder and principal of Little Estate Lawyers. Little Estate Lawyers is a specialist boutique law firm dealing with all aspects of succession law. Danielle assists people with wills and the right estate planning documents to help them avoid any conflicts or problems that might arise after they've passed away. Now, we've been through Ben and Jane's scenario with David from a financial planning perspective, with Rebecca from a family law perspective, but our seminar is obviously called Life to Legacy, so I figure the legacy part is where you come in. So in this situation with Ben and Jane, who is your actual client in this situation? How can you work through that?
Well, in this particular situation, they're both my clients. I can't always act for husband and wife together because it really depends on whether they have an aligned view on what they want to do in terms of passing on their assets when they pass away. So in this particular case, they both have an aligned strategy on what they want to achieve, so I can act for both of them.
Okay. And if they didn't, what would happen then?
If they didn't and they had both come to me for an initial consultation, then I would have to send them to separate lawyers.
Okay. As in separate, independent of you, or?
Independent of me.
Okay. So they don't have to choose who gets to stick with you? They just both need to go and see other people?
Yes.
Okay.
Yes. If they've come to me and had a discussion about what it is that they want to do and I identify that they don't have an aligned view and they need separate independent legal advice, then I can't act for either of them.
Oh. All right. Well, let's talk about that first step with the consultation. Help me kind of work through what that's all about and what you cover in that situation.
So for the initial consultation, we have an information form that they complete before they come in. So we get an understanding of who their family is, who's amongst their family tree, what their assets are, their liabilities are. We understand what it is that they want to do in terms of passing on assets. We get some initial instructions from them. Then when they come into the initial consultation, I go through all of that information with them, ask a few more questions, and I really need to dig down into the skeletons in the closet, whether there are any issues among the relationships in the family, particularly for Ben and Jane, given that they are a blended family. Not everybody gets along, so I need to have an understanding of whether there are any issues there, and I need to have an understanding of really what their personal financial circumstances are, as well as for Jane, her business financial circumstances as well, because it's not just planning for their personal assets to pass on the way that they want to, but we need to make sure that there's succession planning for the business as well.
Okay. Now, it's been my observation just in life generally that sometimes there's a lack of understanding or some misunderstanding around what a will actually does. So what is the purpose of a will?
So a will is designed to document what the technical term, testamentary intentions are, what your wishes are. So it outlines who you want your estate to go to when you pass away. One of the things that people don't necessarily have a great understanding of before they come and see me is what is actually forming part of their estate for a will to deal with, because a will doesn't deal with everything.
Right.
So for Ben and Jane, for example, in their situation, they have a lot of jointly owned assets, which is fantastic in terms of making sure that those things automatically go to the surviving person. but they're individual assets, so they've each got a 50% share in an investment property, and Jane also has a share in her company as well. So Ben essentially has his 50% share of the investment property that forms part of his estate. Jane has the other 50% plus a share in her business, and that is essentially what their wills will be dealing with, because their other jointly owned assets, their joint bank account, their jointly owned house, will automatically go to the surviving joint owner. Plus also their superannuation will make sure that that doesn't form part of their estate, so that it's going directly to the beneficiary that it needs to, using the specific superannuation documents that we need to.
Okay. So does that mean that superannuation is actually not part of an estate?
It can be part of an estate, but it depends how the documentation is done.
Okay. Now, just picking up on some of the things you've outlined there around the will, I've always been of the understanding that a will is a will is a will. But is there more than one type of will?
There is more than one type of will. And in this particular case for Ben and Jane, the types of wills that we are looking at for them is what we would call a standard will. Some people call them an I love you will, or
romantic.
or a testamentary trust style will.
Okay.
So there's benefits and disadvantages to both. In terms of a simple will or a standard will, the inheritance goes directly to the beneficiary outright. So the things that it can't do are things like protecting inheritance from waste, protecting inheritance from things like bankruptcy. It doesn't take into consideration that there might be some tax advantages that would be really good for the surviving beneficiary. A testamentary trust style will doesn't give inheritance directly to a person. It puts it into a trust structure. So that means that we can do things like, if there is a beneficiary that might be at risk from some financial difficulty, we can protect inheritance in that structure from bankruptcy issues. If they're a beneficiary that has potentially some issues, whether that's medical, mental, they might have an inability to really manage financial related matters particularly well, we can have their inheritance managed for them in that trust for their benefit. And there's also some tax advantages as well, particularly for families like Ben and Jane, where there are children that are minors. There's some great tax advantages for using a significant amount of money that would be sitting in that trust potentially to pay for children's expenses tax-free.
Okay. So if you were thinking about your will and you had a concern that one of your kids might spend all their inheritance on a supercar or take it to the casino and put it all on red, is this a way that you can kind of manage that potential risk?
Yeah, that's right. So a testamentary trust, the way that it is structured in terms of who controls it, we can manipulate that depending on what the situation is for the family and what they really need. So if somebody is, for example, wanting to give inheritance to an adult child, and they want that adult child to really have that feeling of getting their inheritance outright, so being in control of everything, we can make that happen with a testamentary trust as well. So it looks and feels like it's just their own money that they're managing. But if there is a beneficiary that does have some disadvantages and needs some support in managing those funds, then we can put in some control mechanisms to help them with that situation.
Okay. So in Ben and Jane's specific situation here, what are they trying to achieve with their estate planning?
So essentially what they are wanting to do is make sure that each other is looked after. So if Ben dies first, he wants to make sure that Jane is really looked after in the first instance, as well as catering for the children to some degree. But when they're both passed away, they want to make sure that the three children are looked after equally. So that's the goal that we're trying to achieve.
Are there other things that need to be considered as part of that process for them?
Yeah, so they need to be looking at things like what happens if Ben passes away next year. They're both reasonably young. And if one of them passed away sooner rather than later, then the survivor is young enough to end up in another relationship. So is Ben wanting to make sure that inheritance does actually flow later on down to his children, rather than Jane giving everything that he's given her to some new partner? I call it recoupling, which is a term that some people don't like.
Recoupling. It's very mechanical.
It is. But at the end of the day, they're both young, so they need to consider what kind of protections need to be in place for that particular scenario, because it's one of the things that people get very upset about is when someone does die young and the survivor does end up with a new spouse and then they want to give everything to their new spouse.
Okay. So after Ben and Jane have come in and spoken to you, presumably we've established they don't have a conflict, what does their estate plan look like from there?
So from there, I essentially go through with them what it is that we need to do. So in Ben and Jane's particular scenario, we need to make sure that we've got wills in place for them. They have decided in their particular situation, having heard the benefits of a testamentary trust style will, that that's the style will that they do want to have for now. They also need some enduring power of attorney documents as well done, so that if they lose capacity, there's someone making decisions for them in their place. We also need to go through things like Jane's company constitution to make sure that the company is going to pass on in the way that she wants, not only the control, but also the shareholders who she wants to benefit from that particular company. We also need to have a look at the self-managed super fund. We need to make sure that the control of that self-managed super fund is going where they want it to go. We also need to make sure that the benefits within that structure are going where they want it to go as well. So we need to make sure we have binding death benefit nominations in place to make sure that there's a valid binding direction where that money goes.
Okay. I've noticed you've used the word capacity quite a few times. What is capacity?
So capacity is your ability to be able to make your own decisions. So if you don't have capacity to be able to make personal and health-related decisions, for example, an enduring power of attorney appoints someone to make those decisions for you. And the joy about having that particular document in place means that you are the one that's in control of who you're appointing to make decisions. Whereas if you don't have that document in place and you do lose capacity, if you're in an accident or something and end up in a coma, someone needs to apply to QCAT, which is the Queensland Civil and Administrative Tribunal, to have someone appointed, and you may end up with someone appointed that you don't want making decisions for you.
And I imagine that takes a fair bit of time too.
It takes a very long time.
Yeah, okay. And capacity in terms of like actually signing your will, is that a separate thing, or how do you establish that?
It is a separate thing. So the capacity to be able to do a will and sign a will is actually a legal test. And we go through certain questions during taking instructions from someone as well as a signing appointment, which the client doesn't necessarily know that we're undertaking a capacity assessment of them, but we want to make sure that from a legal perspective that they are able to properly understand, know the contents of the will and not be under any influence to sign that will, and that they're signing something that they understand and have done freely.
Okay. Now, we mentioned earlier in your introduction that you actually have a lot to do with estate litigation. How does that feed back into your actual planning process?
So the estate litigation is a really good way to get an understanding of the things that can go wrong, not only in terms of the makeup of families, but how wills are done. So it makes us improve our processes with estate planning all of the time. As soon as we see something happen in an estate litigation type matter, we're always looking at what we're doing from a planning perspective to try and avoid that particular thing happening with our own wills and our own planning.
Okay. And if I have a will, like, when should I be thinking about updating it? Is that like something I should do every year, or just when something big happens in life?
We always say to clients that updating your estate planning is something that needs to be front of mind every 12 to 18 months. And whenever some sort of significant life event happens. So if you get married or you separate, divorce, have children, buy a new asset, or ideally before you buy a new asset, great to have your planning done, because sometimes the way you buy it can be problematic depending on what you want to achieve in your planning goal.
It can be expensive to fix later.
It is very expensive to fix later.
All right. So the big question on everyone's lips, I'm sure, is how much is it going to cost me to get a will done? I mean, I know I can pop down to Australia Post and do your own will kit, but to get it done by, an appropriate professional like yourself, what are we looking at?
In typical lawyer speak, it varies.
Oh, it varies. Okay.
It does, and it can vary significantly. It really depends on what type of documents need to be done and some of the elements within those documents. There's not just a standard form that is a suit everyone scenario. There really has to be a lot of thought that goes into the terms that need to be in each of those documents. Also reviewing things like company structures, family trusts, self-managed super funds. There can be not only quite a lot of work in reviewing those documents, but quite often they're prepared very quickly when an accountant has decided that this particular structure is a great way to run your business. For example, they might say you should have a company set up. It'll be a great way to run your physiotherapy practice. So they organise for a company constitution to be done, but they're concerned about the tax benefits for that person while they're alive and running the business. They don't plan for the succession planning of that particular company and how those rules might affect the taking over of control and also the shareholders. So there's quite a bit of work involved in everyone's planning, and we need to make sure that we can do the best job possible for each individual and make sure that all of the documents are really tailored to their needs.
All right, so you've been through the initial consultation process. You understand what Ben and Jane need from a wills perspective, what might be relevant from an enduring power of attorney point of view, and company structures and asset protection. But what else do they need to be thinking about in that regard?
So what Ben and Jane are looking at doing is getting some advice from their financial advisor in relation to owning assets in a different way, in particular their properties. So what they are wanting to look at doing is selling their properties, setting up a family trust, and then buying property in that family trust. So one of the considerations when people have an estate when they pass away are the types of claims that might be made against their estate.
I see.
And in blended families, things can be fine while everyone's alive and everyone gets along well. But what you often see is that it's the children's surviving guardian or other parent that encourages them to make a claim against their parents' estate when they pass away. They don't want to have that mess when either of them passes away. So if they sell their properties and own their properties in something like a family trust, that trust structure sits outside of their estate, so then no property forms part of their estate. So their estate could essentially be worth zero.
So they're protecting their assets by actually not having any assets.
Exactly. And then they can set up the family trust so that the control and passing on of that trust, as well as beneficiaries that are looked after as part of that trust, can be set up the way that they want to make sure that the family bloodline that they want to look after is looked after.
So that does give you complete control over what happens with...
Exactly.
Excellent. So, Danielle, we've spoken a bit about estate litigation and people making claims and contesting wills. Is that an expensive exercise?
It is an expensive exercise. The people making claims against an estate is what keeps me in business.
Okay.
And it's nice to see people have their planning set up so that they have a lot less risk in that regard. So litigation can be really expensive. It's not only an expensive exercise for the person who is the executor of the will to have to deal with, but it's a really stressful exercise as well. It's also really stressful for the beneficiaries that are being affected, because if the estate is paying legal costs, then that means that the pool of money for the beneficiaries is just constantly being reduced.
It's getting frittered away.
There's lots of lawyers and barristers getting paid, and the beneficiaries are the ones that suffer. So I often have a conversation with people about, let's say, for example, a simple claim against an estate is going to cost the estate $50,000. Is it worth spending $5,000 to get some estate planning done rather than having a $50,000 bill for a pretty simple claim? And that's at a minimum. And having your family or your loved ones deal with the stress of that. It's better to spend the money up front, have everything in order, and avoid the risk of there being claims.
Now, Danielle, a friend of mine recently mentioned that as an executor of a will, they're actually personally liable for the administration of that estate. That sounded crazy, but can you talk me through that?
An executor can be in some circumstances, and it really depends on their conduct. So if they are doing things that is not in the best interests of the estate or the beneficiaries and they cause a loss to the estate, then they can be personally liable for that.
So it's their job to make sure that everyone that's getting looked after is getting looked after to the best of their ability.
Exactly. So choosing an executor is a really important thing because you want to have someone appointed that is going to be sensible in a time of grief and in a time of stress and who has the highest of ethics. It is a role of trust, essentially.
Now, I've heard the term advanced health directive as part of this whole estate planning thing, but I don't know what that actually is. Can you give me a bit of an outline about what that might be and why it might be useful?
So an advanced health directive is a document where you're outlining what your medical and health related choices are. It's a document that you go through with your general practitioner. You need to have a really good understanding of each of the things that you're making a decision about. It's designed to take the pressure off the person that you're appointing as your attorney in an enduring power of attorney so that they don't need to make difficult decisions at difficult times.
Right.
So it takes a bit of pressure away.
Okay.
But a lot of people find the Advanced Health Directive quite a confronting document to do, particularly when they're younger people.
Well, hopefully if they've had that date night chat about a financial agreement, then maybe something like an advanced health directive, might be something that they're more comfortable working through.
Particularly after a glass of wine or two.
Well, Danielle, thank you for chatting with us today. We appreciate you sharing your wisdom and insight with our listeners.
Thank you.
I hope you've enjoyed today's seminar called Life to Legacy. The idea behind putting the seminar together was to help people understand all of the legal frameworks and the lesser-known instruments that are available to help you manage your risk, ensure your assets are protected, and eventually when you do pass on, to ensure that your estate goes exactly where you would like it to in the manner in which you'd hoped. If you'd like to speak to David, Rebecca or Danielle, you'll find the contact details below. My name's Brock Fisher. Thank you for listening today.